Yes.
I'll just orally point out what it contained two aspects. My lords are aware, my lord, Article 371A, which provided that first take the list of three entries which the instrument of accession maintained, that is defense, communication, etc. And the president was to find out which are the corresponding entries in the union list. Because defense can have 5 corresponding entries, communication can have wireless, telephone, etc. 5. So, my lord, first act, my lord, which I have mentioned is that, my lord, with which your lordships may directly not be concerned, just by way of, my lord, an example that the Honorable President, by this first CO, identified the entries, that these entries would fall within those three broad subjects which the ruler has given under the instrument of accession. Then it is exercise of powers under 371D and applying these provisions of the Constitution of India. Your lordships would find I'm not reading union, relations between union and states, but all were applied with modifications. As Article 370 or itself, Lord, points out, for example, amendment of the Constitution. 368 was applied, but with a provision in sub-article 6 that any amendment made in the Indian Constitution would not ipso facto apply to the Jammu and Kashmir.
You follow the Article 370 route.
Unless, yes, unless applied through Article 37. So, my lord, in that fashion, Lord, the second part of this CO 10 is,
the first part was with consultation, the second part was with concurrence.
With my lord, concurrence. Concurrence, my lord, consultation is only qua.
As far as 368 is concerned, the constitution can be amended in terms of that article by the parliament and so forth. Now, as far as proviso to 368, it says that the legislative assembly can then adopt, or with concurrence, then it will apply over. Whereas D requires concurrence. Concurrence probably will be prior concurrence.
That would be so.
Because when we are talking about constitution as it exists, 371D refers to the constitution as it was originally enacted.
Yeah.
368 refers to the amendments to thereafter. So there is a slight difference between the two.
Yes. So whatever amendment is made in any part of the Constitution would not apply unless it is so applied either fully or with modification and exception under 371D route.
It will be 371D route or 368 route?
No, it would be 371D route. So I'll tell you, Lordship, why. Lord, suppose the Indian Parliament amends.
Some audio ways.
For that.
368 is not in this red book, no?
No, it is now deleted.
No, but the red book has a lot of other things, but some of the others not here.
But would your lordships like to see, my lord, the original the CO? Lord, that your lordships would find
it should be here actually.
Volume 3.
होना तो चाहिए, देख लो.
Lord, let us take a hypothetical illustration, Manoj. Just, Manoj,
it's just a matter of logics, that's all.
Yes, only 2 minutes, Manoj. The concerned amendment, Lord, in this CO is at page 4 and 9, 4 to 9, in volume 3.
Volume 3, right?
CCD, please come to, my lord, page 8, my lord. The directly, my lord, page 8. And I'll give one illustration only, my lord, at the foot, my lord. Your lordships have, my lord, 360, my lord, part 12, part Roman 12. I'm sorry, part Roman 20. My apologies. Part Roman 20. My lord.
Which page are you?
Page 8, volume 3, the document volume 3, PDF page 8. This is, my lord, the concerned CO 10.
Unless applied by order of the President and a clause.
Provided, I'm sorry.
Yes,
My
you
Lord
got it.
Justice Khanna gets me.
Page
Provided the proviso, Article 368 shall apply subject to the additional proviso, provided further that no such amendment shall have
Just
effect.
1 second. One.
This talks back to article.
Yes, but I'll just give an illustration.
It says.
Yes,
371.
my Lord, just to illustrate, my Lord, for example, Constitution of India amended and inserted Article 21A, right to education, free education, etc. It never applied to Jammu and Kashmir till 2019 because this route was never followed.
Likewise, as you said, the preamble amendment of 1976
Was
46.
applied with modifications, etc.
So the secularism and socialism amendment was never adopted in the case
Yes.
of Jammu.
Yes, even integrity word is not there.
Right.
That was also not applied.
We can skip this now. We can go ahead.
Yes. My Lord, this is contemporaneous. Your Lordship would find the date. It is 26th of January, 1950. So contemporaneous, nothing, my Lord, much turns on that. Your Lordship may, my Lord, directly come to page 49.
Page 49 of the same volume.
Of my written submission. I'm sorry, my written submissions. Lord, it is respondent conjoint written submissions.
Yes.
Written submission, volume 3, my Lord. Lord, 1st May, your Lordship gets the date. My Lord, the Chief Justice gets it. 1st May 1951, Yuvraj Karan Singh issued a proclamation directing the establishment of an elected constituent assembly to draft a constitution for the state of Jammu and Kashmir. Please don't read the note, my Lord, I'll orally point out what it says. Lord, when I take your Lordships to the position of Jammu Kashmir Assembly vis-a-vis our constitution, my Lord, the Constitution of India and the Constituent Assembly of India, Lord, I read that proclamation just to show that it was intended to be subservient to and subordinate to the Constitution of India. But right now, this is a date that the
Mr. Solicitor, you may deal with this, what I'm suggesting, but I'll forget it. So, I was reading a list of dates in the morning, the thought struck me.
Yes.
At one level, you may be right, or subject, of course, to what we have to consider on their rejoinder, that your argument is that the Constitution for the Republic of India is really a document which lies on a higher platform than, say, the Constitution of the state of Jammu and Kashmir. That J&K Constitution, according to you, is subordinate to the Union Constitution. That's one aspect. The second aspect, which you have tried to make out in your note, which we may elaborate it upon it later, which is your contention that, look, the Constituent Assembly of J&K was in the nature of a legislative assembly and not a constituent assembly. That, strictly speaking, that there may be a problem for two reasons. That's not how Article 372, bracket 2 refers to it. It refers to it as a constituent assembly of the state.
Correct.
But more important, once Article 238 made certain provisions of the Constitution inapplicable to the Part 3 states, and particularly the state of Jammu and Kashmir, including executive, legislature, judiciary, which would be brought into force by the Constituent Assembly framing a constitution for the state of Jammu and Kashmir, then it may be very difficult to call it a purely just a legislative assembly. That is an aspect which you may want to deal with. You may deal with it in just one sentence, and then maybe
separate segment, my Lord, of my
then
submission.
we will deal with it at that
I'm
point on the list of dates.
I'm obliged. My Lord, rest of the 3 dates your Lordships can, my Lord, ignore. Kindly come to page, no, not ignore, my Lord, skip. Sorry, my Lord.
And we have read Sheikh Abdullah's address was read out to us by the other side. So we
I'm not
need not
reading, my lord, any address now. I'm just on the chronology
Yes,
and
yes.
chronology which is relevant right now.
Absolutely, you
Which
can
would
go.
rest
Yes,
is, my lord, for completion, but may not, my lord, invest your lordship's time. Then, my lord, Constituent Assembly is created. Now, my lord, comes CO 39, that is 1952 CO. Lord, please see, under Article 371, Lord, these are all appears to be, my lord, powers under 371D, but all COs mention it as 371. Maybe making a little broad source of power of the Constitution of India. In following consultation with the government of Jammu and Kashmir, the President issued the so-and-so order 1952, modifying Article 54 and 55 of the Constitution insofar as it applied to the state of Jammu and Kashmir. By this CO, for the first time, President recognized the Constituent Assembly as the Legislative Assembly for the purpose of election of the President of India. Your Lordships would, my Lord, note, when Constituent Assembly of Jammu and Kashmir was formed, obviously there was no Legislative Assembly because that was yet to be a part of the Constitution to be framed. So as to ensure that they do not lose their representation in election of the President, Lord, this CO was issued that you will be treated as Legislative Assembly also. Lord, your Lordships would find at the end of this chronology, 370 has been applied in kind of a floating way. Whenever, my lord, it is required to use the word interchangeably, it is logically so used. And whenever any word has become OTOs, it is replaced by its successor. Look, this
at that point, there was no legislative assembly at all.
at all, correct. I say
Therefore, they had to make this CO
correct.
to read that instead of the word legislative assembly shall also include a reference to constituent assembly. Because at that point, there was no legislative assembly.
My lord, exactly that is where, my lord, I would respectfully drive it. When there is no legislative assembly, the constituent assembly, the president has said that now it would be treated as legislative assembly. But that I'll come little later. But it has been used, my lord, kindly see there are two, my lord, prominent features in COs which comes up.
Yes.
A, it has been used in a floating way, some words used interchangeably. And second, and most important for my purpose, whenever a word in Article 370 becomes OTOs for that post not being in existence, that body not being in existence, it is immediately replaced by its successor. Sadr-e-Riyasat is replaced by governor, etc. Now, my lord, your lordships may come to the next date, 20th of June, 5th. There was a letter, my lord, referred to by Mr. Gopal Shankar Narayan, where Dr. Rajendra Prasad, the then Honorable President of India, writes to the Prime Minister, Honorable Prime Minister Nehruji, that this can be used only once, etc. That is being used, that can be used, my lord, in buttressing the arguments which I am also advancing. But we also got, my lord, the response of the Honorable Prime Minister. I'll put it, my lord, when that fact comes, my lord. And thereafter, the same Honorable President issued, my lord, order under 370 sub article 3 also. So, my lord, literally, actions speaks louder than words. That was, my lord, the understanding, but the understanding was that it is so drastic a provision that use it only once. It's an self-extinguishing provision. That's my lord, the tenor of that later. My lord, while the Constituent Assembly of Jammu and Kashmir was in session, Lok Sabha also continued its session. In New Delhi, as per Constitution of India, during one of the Lok Sabha debates, My lord, please see, my lord, how our parliament understood Article 370. My lord, the purpose is to satisfy your lordships that Article 370 is not just stated to be temporary. Legislative Assembly debate says it is temporary. Even during the subsequent parliamentary procedure also, everyone treated it as a temporary measure. But only for that, but this is N.C. Chatterjee. But incidentally, he was the counsel in Premnath Call judgment. N.C. Chatterjee, he must be a member of parliament also. I'll just read the underlined portion. I maintain and I say that with all earnestness that under the law, under constitution, accession to the dominion of India under section 6 of the Government of India Act as amended after the Indian Independence Act was final and irrevocable, and there ought not to have been any question of plebiscite. I maintain that accession is final and irrevocable. Under our constitution too, Kashmir is an integral part of India. Under Article 1, the Indian constitution consists of federation of states and it is a part B state. There cannot be any going back on that. But the unfortunate thing is that the Constituent Assembly is doing something there which is against the spirit of our constitution. I know my honorable and learned friend Dr. Kaju will point to me Article 370 of the Constitution. Article 370 is part of Chapter 1221 and it deals with temporary and transitional provisions. Then, Dr. Mukherjee, in a democratic federal state, the fundamental rights of citizens of one constituent unit cannot vary vis-a-vis the citizens of another unit. Are not people of Jammu and Kashmir entitled to the fundamental rights that we have given to the people of India minus Jammu and Kashmir? There is no scope for varied constitutional patterns, disparities as between one federating unit and another. The legislative or executive authority of the units in respect of the states will be coextensive with the similar authority in and over the provinces to certain adjustment during the transitional period, the fiscal relationship, etc. Then, my lord, Pandit Ji, as the Prime Minister and Minister of External Affairs, Lord, responds. So, Kashmir obviously is a constituent unit of the Federation of Union of India, but a difference has arisen, subsequently arisen. You please remember that, not originally, between Kashmir and other states, because subsequent to the earlier accession, the other states have become integrated, more which Kashmir has not and could not in the circumstances as I have tried to point out. But nevertheless, it is a full constituent unit of India. Various things flow from it, various consequences. Consequences, for instance, in regard to the President of the Republic. The President has certain authority which he exercises on behalf of the Republic, and wherever the constituent unit may be, the President will exercise that authority in that measure. But come to the last line. But the President's ultimate right has to remain for a constituent unit of India. That irrespective of 370, the President of India's right, which he exercises on behalf of the Republic, which he exercises on behalf of we the people of India, must remain as a plenary power without any fetters. My lord, that's how the Parliament understood. My lord, thereafter, my lord, your lordships would come to, my lord, page 52. First two dates your lordships may skip. My lord, during the Jammu and Kashmir Constituent Assembly debates also, my lord, I have quoted, but I may, my lord, just paraphrase it and proceed further. Lord, it says, every member says that this is temporary. They also understood it to be temporary. Lord, I am not laboring on the point right now why it is temporary. The point is, which I'll ultimately make, despite full knowledge that Article 370 is a part of the Constitution, despite having accepted in the Constituent Assembly debates of Jammu and Kashmir that it is temporary, they chose not to make any recommendation under sub-article 3. My lord, that's a separate limb, and I'm just flagging it here. Kindly see, my lord, highlighted part. This assembly came into being because of section 370 of the Indian Constitution, and it was because of the section that we enacted such laws as were necessary for our society. So, Lord, they understand that its very source of existence was Constitution of India. Lord, kindly come to page 53, third. Lord, this is third date, 15/11/52. Lord, this was the first use of Article 370, sub-Article 3. So kindly note this.